well, the court has no power to solve the problem of an ineffective registration or no effective registration being in place at the moment that a company enters administration or liquidation. That is a completely fatal flaw, but there are other issues that the court can fix. So, for example, if a registration is made late, but you detect the issue before your counterparty goes into administration or liquidation, then you can go to court quickly and fix it, but it does require you to act urgently.
Cathro Partners presents The Cut, a podcast about all things insolvency.
Well, hello everyone. This is season 3 of The Cut. My name's Simon Cathro from Cathro Partners. I'm the managing principal. And welcome back to everyone to the 2024 season. We are focusing this year on the legal industry and technical topics. Primarily it focuses on insolvency and restructuring and other areas of law that where we can learn from some of the legislation that exists in the market. Our first guest for the year is Tom Gardner from Gilbert Tobin. How are you, Tom?
I'm good, Simon. Thanks for having me on the podcast.
And Tom and I have worked together on many assignments, from manufacturing buses to cosmetics chains to food delivery services, and we've both been operating now in a number of years in the insolvency space. But Tom, how about we get you to give us a bit of background on who you are and sort of how your career's sort of been today?
Sure. So as you mentioned, I work at Gilbert Tobin. I'm a restructuring lawyer there, so we act for lenders, borrowers, insolvency practitioners, the government and other stakeholders in distress situations and insolvencies. I started out my career, the first thing I did after graduating university was to work for a judge, Justice Black at the Supreme Court. And he deals with a lot of insolvency matters, so I was exposed to it there.
Yeah.
And really enjoyed that. And then went on to be a graduate lawyer, and then from 2018 have worked in the restructuring and insolvency space, and about 5 months or so ago came over to Gilbert Tobin.
Yeah. So working for a judge, that's pretty hard to get into, isn't it? Right.
Fairly competitive and interesting diversity of people who work for judges, all sorts of pretty ambitious, driven, talented people. Yeah.
Yeah. And what do? You help them with the decisions, or what's sort of the role when you're working for a judge?
Look, everything from administering oaths to witnesses to getting the cappuccino for the judge to...
I was going to ask about the coffee.
Yeah. Collecting files, proofreading judgments, research.
Yeah.
Wearing a robe. And
it gives you a good grounding around getting into the legal industry too, just learning that, that time with the judge, you really learn some, how the law operates and stuff.
Absolutely. You see all sorts of things in court.
Yeah, great. Well, today we're talking about PPSR, which is I'll let you talk and define what the acronym is because I always forget, but it's an area that is very active, particularly in the insolvency and restructuring space, and is a law. It requires some real specialty to understand, but what if I let you just talk around what the PPSR is and just give our viewers a bit of an outline as to what it is, and then we can ask some questions from there.
Sure. So the PPSR is the Personal Property Securities Register, and anyone who has a security interest in what we call personal property, that's any property at all that's not land. So anything from goods that are supplied to motor vehicles to shares, debts, anything like that. They need to register that on the PPSR.
Yep.
And if they don't, they might lose that security interest, or they might lose priority to that security interest. So the importance of registering and registering properly is huge.
Yeah.
Big financial consequences. And the reason it's topical today is that for the first time since the PPSR was introduced in 2012, the government is performing a review, which is going to make hundreds of changes to how the PPSR works.
Yeah.
And they've just completed a consultation process with a view to sounding out views from industry and from professionals in the insolvency and finance sectors about how those changes should be implemented and how they'll work.
Yeah. All right, we'll come back to that a bit later, but let's take a step back. 2012 got introduced. Before that, we had lots of problems. We had buses going missing. We had quadrupling of leasing of the one bus, and I keep raising the bus. There was some famous insolvency matters that had buses where they were multiply leased by many leasing companies. So why did the legislation come in the first place?
So it solved a few different problems. One is the one you mentioned, Simon, which is that if there's property where there's no notice board of who has an interest in the property, then you have what's called multiple grantor problems, which is what you just mentioned, where people mortgage the bus to one person, then lease it to another person, and then sell it to a third person, and then who has what rights in the bus? Impossible to say, very difficult, and everyone kind of loses out because there's no way to check who already has interest in that bus. Another was that there were existing notice boards, but they were very fragmented. There was the Register of Company Charges, which operated at a federal level for companies, and then there were various other registers at state and territory levels over different kinds of property, and you had to do all sorts of searches in order to figure out what security interests had been granted over the property of a particular individual or company.
Yeah. And I imagine that prior to the Act, where you had these situations of an asset being multiply leased or financed, I imagine the first financier would be the ultimate beneficiary, and then the others would be sort of burnt in some sense because they've taken insufficient security. And is that sort of how it worked in the past?
Often it would depend on the circumstances, and really there's no good solution to that problem because the second and third people in that scenario are completely innocent. They've taken their interest in the property in good faith and for value, and the law tried to, I suppose, balance the interests of those competing claimants to the property and had different solutions to that, but none of them are as good as having a notice board where you can reliably check what interests already exist.
So let's talk about the notice board. So law comes in. We've got this complete overhaul of this area. Lots of problems. I can speak personally as a practitioner that prior to 2012, it was a complete nightmare. And having to deal with people that have got improper security, and that is quite emotional, and a lot of angry people. So it comes in, and let's talk about how does the process work now?
So now, if you take an interest in personal property, whether it's a charge over that property or whether you have you're a transferee of that property in order to secure some rights against the transferor, or you're a lessor of that property for more than 2 years, you have to register what's called a financing statement on the PPSR.
Yeah.
And it's pretty cheap and straightforward to do. And it just has the basic information of who you are, who's giving you the interest in that property, and what your interest is.
Yeah. And so a party comes along and wants to deal with that particular asset. They can do particular searches on this notice board, and they can find out whether that particular asset's got some form of security or loan attached to it.
That's right.
Yeah. And it's one area. It's not in multiple areas, like you said earlier. Pre-2012, they can look at that. Then moving on sort of from there, you've got you've had a number of cases over the last 10 years where we've had case law developed on what's in an invalid registration. Talk me through some of the examples that we've seen over the years that have got people into problems around the validity of their security.
That's right. So just stepping back, the reason that we're concerned about the validity of a registration is because if the registration is invalid, then it doesn't count for anything. You don't get priority over other people taking interest in that property. And if the person who gave you that interest becomes insolvent or bankrupt, then you might lose the interest altogether.
Yeah.
And the different ways in which the registration might be defective are usually that you've not described the grantor properly, and there are particular ways in which you have to describe the grantor, and that needs to be quite specific because anyone needs to be able to know that if they search for the grantor in a particular way, for example, by their ABN, their ACN, their name, that they'll get a complete list of results and that there won't be any missing. So if you don't use the right descriptor, whether it be the ABN or the ACN or the name or some other identifier, then your registration won't come up on people's searches and therefore it doesn't count. And as you mentioned, there have been some high-profile cases of mistakes being made with describing grantors, and some very, very high-value property has been lost as a result. Really valuable machinery or wind turbines. Millions of dollars could be at stake.
Yeah, there was a particular big one around the use of the ABN and the ACN. There was that one that was quite famous, I suppose, if you want to use that word in our industry. Do you want to talk through that one?
That is one of the most common issues, and that is actually one of the things that the government is currently proposing to change. So the current rule is you have to register against an ACN of a company, not its ABN. And if you use its ABN, then your security interest registration is not effective, except that if the company is granting that interest as a trustee, then you have to register against the ABN of a trust.
Yeah.
If there is one.
Very technical.
Very technical. And so it's being a bit simplified so that now you just register against the ACN of the grantor, regardless of whether it's granting that interest as a trustee or in its own capacity.
Yeah. Yeah, so this is where the area of the law, this particular law, gets very complex, and why you need to get legal advice in that sense, because of the fact that if you make a simple mistake as it currently sits under the legislation, you could very well have an invalid charge in security. So let's talk about the changes to the law, and maybe we spend a bit of time on just going through the purpose of. Let's start with why did this review come into play? What was the motivating factor?
So when the PPSA was first introduced, the PPSA being the legislation that governs the PPSR, Parliament specified that there should be a review into the operation of the register within 3 years of it first coming into operation. That review was completed in 2015. Hundreds of recommendations were made about how to improve the operation of the PPSR, and none of them have ever been legislated. And now, some 8 years on, the government is finally picking up that review that was tabled in 2015 and saying, okay, let's actually implement most of these recommendations.
And do we know the timing of when this is happening, or is it still unknown?
I expect it will take quite a bit of time. So the consultation process for the proposed changes has just closed. The government will need to take away submissions made, consider them, revise the proposed legislation. Then it needs to go through Parliament.
Yeah.
And after all that's happened, there'll be an absolute minimum 24-month transition period, during which the old system will have to become a whole new system, and that will be a very complicated transition.
Yeah. Okay, and so in 2015 we had the review. It went through and found a whole lot of loopholes, errors, weaknesses in the law. What are some of the proposed changes that you think we'll get through in this in these reforms? So we talk about the ACN one, and what are some of the other areas that it will touch on?
Sure. So thinking especially about, on an insolvency podcast, the more insolvency-related ones, a big one is that insolvency practitioners, administrators, and liquidators will be used to, at the beginning of an appointment, to identifying property in the possession of the company. And if it's been leased to the company for more than 2 years and there's no effective registration on the register with respect to that property, then as things stand, it currently vests in the company. That rule is proposed to change, and the new rule will be that that property doesn't vest in the company, but it might be captured by an earlier ranking security interest over all of the company's property. So it's going to change whether, for example, that property could be used to otherwise fund an administration that is relatively assetless. It's going to adjust people's expectations around the way that works. So, for example, like a motor vehicle or goods inventory that was on the company's premises before that would otherwise have been available to the administrator, that might no longer be the case.
Well, let's talk about an example then. So you've got a motor vehicle. So we've got a cleaning business. So they've got 10 contracts, goes into voluntary administration. That vehicle is subject to Toyota Finance or someone like that. And the law changes the way you think it may. I get appointed as administrator. What, are you saying that once my appointment happens, that vehicle, which is the key part to the cleaning business, let's say, is not an asset I can use anymore? Is that sort of what you're talking about?
So Toyota Finance, I'm sure, will have an effective registration with respect to that vehicle because they do this day in, day out.
Yeah.
But if someone less experienced had tried to make a registration and gotten the serial number wrong or described the company wrongly,
Right.
previously that asset might have been available to the administrator to use as the administrator's own or the company's own. Now it will either belong to the lessor or to a competing secured party, but it no longer vests necessarily in the company.
And so I can't use it during the voluntary administration period.
So it can be used and the security interest can't be enforced during the VA period, but after the VA period ends, it'll go back to whoever the lessor was or whoever else has the interest. It won't stay with the company.
Right. So if we're looking to, say, restructure a business and let's say a good portion of the assets are subject to lease or some sort of PPS registration, it's quite possible that you could get a deed of company arrangement approved by creditors, and then at the end of that, when it does enter into a deed, those assets that are subject to lease can then get taken by the financiers. Is that what you're saying?
This scenario only applies where there's a no registration or a defective registration.
Right. Okay. But if it's a valid registration, which is what we see most these days,
Yeah.
I mean, people have got their ducks in order these days because they've got proper legal advice, then it doesn't really change the current way that administrators operate.
No, that's right.
Right.
Having said that, I would expect that there might be a slight uptick in invalid registrations because of changes like the ABN ACN one.
Right.
We might be seeing registrations made against the ABN that will now need to be made against the ACN going forward, and those will start to become invalid.
Right. So, and there'll be grandfathering provisions to deal with the current situation, so they can, and that's the 24-month that you're thinking that you're saying.
Look, that's an excellent point. That whether there'll be a grandfathering system is still up for debate.
Yeah.
The government has two options in mind. One is grandfathering, where all the old registrations will continue to be valid as they always used to be.
Yeah.
The other is a kind of migration system, where all the old registrations would be converted into new style registrations, and that may require some action by secured parties to update them during that transitional period.
Yeah. So let's think about this then. So you're a business, you're a healthy business, you're making lots of profit. These law reforms come in. What is it that the actual business owners should be thinking about where they've got a business that's got a number of contracts that have got PPSR registrations on their assets? I mean, what is it that they will need to do? Will there be many changes, or what is it? What is it they would have to do?
So, insofar as the business is buying or the lessee of property, they needn't be too concerned about these reforms. The changes for them won't be as big. But if they're selling goods, especially on retention of title terms, on consignment, or they're leasing goods, or they're taking security interests from anyone, for example, as part of their supply terms, they might be taking some kind of security interests, or they might be lending money.
Yeah.
In those circumstances, they really need to look at their systems and processes and double check whether the PPS registrations that they're making at the moment will continue to be effective after the new PPS reforms come in.
Yeah. So it almost sounds a bit like a mini version of what happened when the law came in the first place, where there was a horrendous amount of work that had to do, particularly financing companies, to get these registrations corrected, updated, changed, whatever. So it sounds like it's almost it's happening again. Is that sort of your view?
Yeah, and I think the government is conscious of that.
Yeah,
and aware that a lot of time will need to be permitted to allow I mean, whole computer programs will need to be rewritten to enable the registrations to be made properly. The software of the PPSR itself will need to be changed because the financing statements will look quite different. And yeah, there'll be some teething issues.
So we go back to 2015, they find all these hundreds of changes, right? But in 2012, they introduced this legislation, which was a huge change, right? Massive change. And I remember it. And then 2015 does a review of that new law. And it sounds to me that we're doing huge changes again. Like, is there any motivating factors to, I mean, apart from, you talk about the ABN and ACN example, like why does it feel like we're almost going down that same path as 2012 again, where we're just doing a whole overhaul of the system?
Well, I suspect what you've touched on is the reason why the government had previously put this in the too hard basket and thought, although these changes are sensible, we can live without them and we don't need to go through all the drama of redoing this whole PPSR. It's just too much. But the changes do make sense. They do make the PPSR probably easier to use, particularly for suppliers and lessors who aren't using it every day, but do need to make registrations and find some of the terminology especially confusing and some of the rules overly technical. And to give you an example of that, you'll be familiar with, and a lot of your listeners will be familiar with, purchase money security interests, which is a concept in the legislation which at the moment secured parties have to nominate in their financing statements whether something is a purchase money security interest or not. Now, many people don't know what that means, and essentially they get it wrong, and if they get it wrong, their registration could be ineffective. So the whole notion of having to specify whether your security interest is a purchase money security interest is going to be abolished, and that will hopefully, for secured parties, improve the rate at which their registrations are effective.
Well, let's so what's the example of a purchase money security interest? A PIMSI, I think we call it in our
PIMSI,
world.
a PIMSI, as it's affectionately known.
What's an example of one? So a basic one.
So a purchase money security interest is, for example, you finance someone to buy a car, you give them a loan to buy a car, and then they give you a security interest to secure their obligation to repay the purchase price of the car.
Yeah.
And the reason that that's called a purchase money security interest is because you funded the purchase money for that security interest. And the reason that we need that concept is because that PIMSI has a higher level of priority than other security interests in recognition of the fact that you didn't just take a charge over that car out of nowhere, you actually funded the car.
Yeah. One of, it's a very technical and lots of legal jargon act. Like what I find when I listen to PPSR and then I just compare it to the world I live in, which is the Corporations Act, it's very hard to comprehend in comparison to sort of the way you read sort of the Corporations Act. And I think for your layman person, it's almost next to near impossible to really comprehend the terms, because it is, I mean, I think only the Insurance Act probably has a worse act in terms of understanding it's like a different language almost. It's like we speak English and then there's the PPSR language. I think it's important, I suppose. What are the sort of key things that, say, a business owner should think of when they're running a business from and they've got this ability to access this kind of money? Because let's put it into, and I hope I'm being clear here, you've got lots of options around accessing cash, right? And accessing cash in a business, and that's through your debtors, financing, cap equity. But then I suppose when you're looking at a sale and leaseback type situation, that could be the sale of plant and equipment, it could be the sale of property. This is where the world of PPSR starts to sort of jump into that world. What are the things that they should be cautious about when it comes to going down that path like a sale and leaseback type situation?
So a sale and leaseback, a great way to access liquidity if you have that ability to do so. Again, probably from the point of view of the vendor or the lessee, the person accessing that liquidity, minimal PPSA related risks there.
Yeah.
But from the point of view of the financier, much more significant risks. For example, is that sale and leaseback a PIMSI or not? You have to tick the right box. Often you have to make 2 registrations to make sure that you've definitely got the priority that you think you do. And the other risks, typical risks are you describing the grantor correctly? Are you describing the collateral correctly? Have you got an effective security agreement in place? Have you identified your counterparty to the security agreement correctly? These are the risks we see coming up.
Okay. And so the short answer is engage a lawyer. I appreciate from the financier's perspective that sometimes the reason why it takes so long to get financing is because of these kind of technical issues that the financier needs to make sure they are properly set up and they're properly protected. And that might be why there's a delay. Like it's not as simple as signing I think I put some stuff in storage on the weekend. You just sign a form, and it's within 20 minutes you've got a contract, and it's pretty simple, right?
Yeah.
This is a much more complex thing, and people should just appreciate that. Things have to be done properly to make sure that the registration's set up properly. Let's just move into some case law and some interesting cases that have happened over in recent years and in terms of PPSR. Is there any one or two that sort of stick out for you that's worth talking about?
Yeah, well, in terms of ones that I've worked on, they're definitely ones that stick out for me. So on 2 occasions, I've made, together with my team, my supervising partner, Orla McCoy, court applications in order to remedy the issue of registrations being made first defectively and then late on a very large scale. I've also made a number of other applications where the scale wasn't as huge, but these 2 larger ones, we're talking about tens of thousands of applications, tens of thousands of registrations being made against collateral that were ineffective and lost their priority because the effective ones were made too late. And in both cases, the reasons for those ineffective registrations were essentially computer bugs. So if you have a secured party, a financier, who's operating at huge scale, you want, in order hopefully to ensure the efficacy of your registrations, to have them being made by a computer in an automated way according to a carefully audited, monitored system, which has been instructed to set up these registrations correctly, automatically, immediately, and on time. Fortunately, as we know, humans are fallible, but sometimes technology is too. And if a bug creeps into these registrations, it's sometimes the case that causes the registrations to be made defectively, and those defects might not be discovered for months.
Like a computer virus? Would that be?
Like, for example, an update to a system that's gone wrong.
Yeah.
Or instructions that just weren't quite right in the first place.
Yeah, right.
And this may only come to light when a liquidator is appointed to a grantor and carefully looks at the register and says, hey, actually, this registration doesn't count for anything. This collateral belongs to me now because there's no validly registered security interest. And then all of a sudden, my client looks at all of its registrations and realizes, wow, we've got tens of thousands of ineffective ones, and then a court application needs to be made to fix them.
Yeah. So just thinking about this this matter that you've acted for. So there are laws or abilities within the Act to rectify things when something is defective. Is that the case?
Yeah, exactly. So they're not unlimited powers. For example, the court has no power to solve the problem of an ineffective registration or no effective registration being in place at the moment that a company enters administration or liquidation. That is a completely fatal flaw.
Yeah.
But there are other issues that the court can fix. So, for example, if a registration is made late, but you detect the issue before your counterparty goes into administration or liquidation, then you can go to court quickly and fix it. But it does require you to act urgently.
And it's really just making it or reflecting what the real intentions were right at the beginning of the time that the parties entered into the contract to say, well, this is exactly what we wanted, but this is something else came out because of this defect or something like that. So it's really just a reflection of the true agreement in some sense.
Absolutely. And then the court also considers, well, will other people who have relied on the register in the period in between when you should have registered and when you actually did, have they been disadvantaged? And if they haven't been disadvantaged, then there's no reason for the court not to grant the relief they're seeking.
That was going to be my next question is, when does the discretion, sounds like a discretion or a power or something like that the court can apply? What would be an example of where the court would say, no, sorry, you can't fix this? What would be an example of that?
So I'd say the main cases would be if the administration or liquidation has already started, then the court has no power to fix the absence of a registration. If the secured party has delayed in making an application, the court may say, on a discretionary basis, I'm going to refuse relief. And in particular, if some other competing secured party has relied on the register in the intervening period, then it's very unlikely, I would say, that an applicant before the court would be able to convince the court that they should get a priority over that secured party.
Yeah.
Maybe over future ones, but not past ones.
Okay. So other examples, high-profile examples or other case law, is there any others that are of interest?
Yeah, cases coming before the court very frequently. There was one recently, just a few weeks ago, where a secured party was wrongly described in a very large financing arrangement worth tens of millions of dollars, and they made a court application in order to solve that. These sorts of small issues can come just through human error, the wrong description being used, and the wrong details being entered into the register. And to put that into context, I think one of the main goals of the reforms that have now been proposed by the government is to reduce the number of data points that need to be entered into the register so that fewer mistakes are made and the register is easier to use, and these kind of issues come up less frequently going forward.
Yeah, so then there's less case law and less people going to court because it's a lot more clear as to what the actual situation is.
The flip side, I'd say, for insolvency practitioners is that when they do a PPSR search at the beginning of an appointment and they look at the register, they currently have a fair amount of information, and that information will decrease in the future. So there'll be less information about what kind of collateral registrations relate to. There'll be no information about whether things are a PIMSI. There'll be no information about whether the secured party has control or whether there's a subordination agreement in place. A lot of these, no information about whether an item of collateral is inventory or not inventory. These sort of data points won't need to be entered into the register anymore.
Yeah. And do you think there'll be less cases now because of it, or you just think it'll just be more?
Look, if I had to speculate, I'd say there might be a little bit of a spike.
Yeah.
Just because of the confusion and mistakes that will arise from these changes.
Yeah.
But then after everyone's settled into the new PPSA, hopefully there'll be fewer disputes. Having said that, there are some ways in which vesting issues and disputes might actually increase because the PPSR changes include some changes that will increase the requirements on a secured party in relation to what's on their financing statement. So one big example there is, at the moment, the description that a secured party enters of the collateral that it's taking a security interest in, so long as it's not seriously misleading, it's effective.
Yeah. Yeah.
The new PPSA, as it's proposed, is going to say, even if it's not seriously misleading, if collateral that you have a security interest in falls outside the description that you enter on the register, then your registration is not effective with respect to that collateral, even though you have a security interest in it. So to take
what's a practical example of that?
Example,
Yeah.
If I take security in your guitar, your piano, and your tuba, and I describe the collateral as musical instruments, that's fine.
Yeah.
But if I say I have security in your tuba and your piano, then I'll only have a perfected registered security interest in those two instruments going forward.
Yeah.
At the moment, so long as my description is not seriously misleading, there's an argument that I have a perfected registered security interest in all of your instruments.
A semi-trailer could be a good example because you've got two parts to the semi-trailer. You've got the bit that carries, and then you've got the engine and the vehicle itself. Like, is that something that could be a great example of where this could be a problem, in the sense that you get a lease and it's the truck, the actual engine, the part that has the engine and the pulls the load, and then you've got the actual container part of the truck. Is that a good example of where someone on the lease it could say the semi-trailer?
It is, yeah. So often you'll be making those registrations against the vehicle identification numbers, but if you're making them under the goods collateral class without using the identification numbers, and sometimes there are good reasons why you do that, then you'd just be using a free text description of the collateral. Yeah. And if you just say semi-trailer, then there's a risk there that you haven't got perfected security over everything that you thought you did.
So if you've got an asset that can detach itself into many pieces, the question then is it's really up to the financier. It's not really up to the borrower to worry about this. But if you're the financier, you should be saying, well, if this particular asset that I'm going to provide financing and take security over is able to be pulled apart into pieces like a truck, we should be really looking at the description.
The description is going to become more important, yeah. So, which is why descriptions such as all goods supplied to the grantor from time to time are so common, is because they're pretty fail-safe.
Yeah.
If that's an accurate and not misleading description of the security interest you've been granted, it's a good one because it doesn't leave any room for doubt. It captures everything.
Yeah, great. Well, a couple more minutes to go, but why don't we wrap things up with some key takeaways? Maybe 3 or 4 points or whatever, just on what. Let's start with the insolvency practitioners. What are some of the things that we're going to have to be conscious about under what you expect the proposed laws will bring?
So I'd say be prepared for the PPSR to contain less information than it used to do. Consider some of the new ways in which property might vest that it didn't vest before. So I mentioned, for example, the collateral description. Another one is that multiple grantor registrations, so registrations against several grantors, will vest in more situations. There are a few of these out there. Be alert for these because they're opportunities to take property that someone else has a potential claim to and say, no, it belongs to the company now for the benefit of creditors. And I'd say keep a close eye on how this PPSR review continues and give your feedback to the Attorney General's Department about how it will impact you. I know the Australian Restructuring, Insolvency and Turnaround Association has made a submission that seeks to reflect insolvency practitioners' interests in the effective use of the PPSR.
Yeah, good, okay. What about just a business owner? What are any key takeaways for them?
Yes, if they are supplying or leasing goods to people, they need to carefully review, after these changes have been finalised, their process for making registrations against their customers. Because even if you had it right before, you may not have it right once these changes come into effect.
Yeah. And just to really go back, the whole reason this whole legislation started was to reduce fraud in some sense. It was to provide more clarity and to make sure that people weren't abusing and doing fraudulent transactions to access cash when they're on assets that they couldn't finance against. That's sort of one of the key drivers, was it?
And I'd say despite the many issues that we do see, it's easy to be overly negative about it when you see defective registrations all over the place, but I'd say it's done its job pretty well.
Yeah, great. Well, let's wrap up there. Thanks, Tom. That was great.
Thanks so
much,
much,
That was
Simon.
A very technical topic. But look, for those watching, the PPSR is a very technical area. It's something that you should always engage lawyers on, including insolvency practitioners and even those that in our industry that have a lot of experience. It's good practice to engage lawyers to make sure that it's been properly reviewed and assessed. Tom and his team and the team at Gilbert and Tobin have got a lot of experience in this space. Tom's got a particular passion about it. So thank you, Tom. Thanks for coming along.
Thanks, Simon.
Thanks for being my first guest for the year of 2024 in season 3. But thank you very much.
Absolute pleasure.
Thanks for tuning in to Cathro Partners, The Cut. We hope you've enjoyed today's episode. For more insights, please visit our website, cathropartners.com.au, or find us on LinkedIn.